thought I'd begin with a reminder about some of the key provisions of the Bill of Rights, which are being blatantly violated by the federal government with apparently no recriminations. Article 1, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press, or of the right of the people to peaceably assemble and to petition the government for a redress of grievances. Article 4, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, this is the habeas corpus issue, and supported by oath or affirmation, and particularly describing the place to be searched or the persons or things to be seized. Article 5, no person shall be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Article 6, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, and to be informed of the nature and cause of the accusation, to be confronted with witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. And then further on, after the original 10 Bill of Rights, Article 13, neither slavery nor involuntary servitude, except as punishment for a crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. And Guantanamo, of course, comes to mind immediately. Well, the NDAA violates virtually every one of these. Indefinite detention, no trial, no jury, no judge, no witnesses, no evidence. Just, we'll keep you here as long as we want to. And this is a very alarming development, to say the least. Well, right after the Patriot Act was passed, the Bill of Rights Defense Committee was formed in Northampton, Massachusetts, and now has branches all over the country. And Michael is here from New York, and I will turn it over to Michael.
So thank you all for coming. I thought I would start by talking a little bit more about the formation of our organization and how we see the Bill of Rights, constitutional rights, civil liberties, and our sort of theory about some of the most effective ways to defend them. And so as John mentioned, we were formed after September 11th, after the Patriot Act was passed, when we realized that people around the country were horrified by what was going on with the Constitution, the way that it was being trashed with the Patriot Act, the way that the government was asserting the authority to search through people's library records, search people's homes without telling them about it, monitor their phone calls and conversations, do these black bag searches, lock people up indefinitely without trial, these type of things. People were really shocked by this, and it became apparent that it wasn't something that was just occurring in places that were, you know, maybe people would think as sort of hotbeds of civil liberties activism, you know, traditionally liberal cities or something like that. It was something that was really occurring across the country in small towns, cities, large cities, counties, where people were really outraged by this. So we worked with people across the country to work with their local legislatures in cities, towns, to pass resolutions declaring that this was unconstitutional. People were outraged by it and something needed to be done. And sort of our theory of organizing that we've applied more broadly, looking past the Patriot Act to now indefinite detention under the National Defense Authorization Act, to more currently the use of drones across the country, to the co-opting of local law enforcement by federal authorities regarding immigration, these types of issues. Our sort of theory about how to go about this is that people really have the most access to their local legislatures, their local city councils, their county councils, their state governments, and they have the most influence and power over those legislators, either because those folks agree with us and understand that these constitutional violations are outrageous, or because we can really bring power to bear on these folks very strongly because they need to be reelected and want the support of people and want to, we can tell them what is right is what's constitutional and demand that they act in accordance with, what we know to be abiding by the law. So what's happened with the National Defense Authorization Act, I think people have come to understand and more people are being educated about, is really unprecedented in a lot of ways in our country, because what it does is it deploys the military, or allows for the deployment of the military domestically on U.S. soil to arrest and detain people indefinitely without trial, as John mentioned, essentially possibly forever, without ever allowing them access to an attorney, without ever allowing them access to a court, without ever having any sort of check and balance on the federal government's decision to throw them in indefinite detention, potentially for the rest of their life. And so one thing that's novel and shocking about that is the deployment of the military on U.S. soil, because there's something called the Posse Comitatus Act that was passed a long, long time ago, near the founding of this country, that expressly prohibits that. It says that the military will not be used for domestic law enforcement purposes, that the military is used to fight foreign enemies, to fight wars, but not to be deployed in the United States. It's something that's simply undemocratic, it's authoritarian, and people rightly have resisted this until now. And I mean, most people haven't suggested it because it was so outrageous, it just wasn't even, on the radar. But now the Congress, and then President Obama, who said that he was going to veto it, but then of course didn't, and did the same thing this year when it came back up again, just allowed it to happen. So now it's the law, and people across this country have been increasingly getting educated and outraged by this. So we've seen, I think, in over 24, I believe, different jurisdictions across the country, there are bills in progress that have declared that people are opposed to this, that either that their state will not help to enforce these laws, they won't assist the federal government in enforcing indefinite detention. And some states have even suggested that it might be a criminal offense to participate in this, to go against the Constitution, to detain people indefinitely within that state.
So what we're seeing and what we think is really possible here is that the groundswell of support across the country that's coming up really might be something that will end up changing this at a federal level and end up pulling these provisions back out of the law. Because it's not just people calling up their congressperson and saying this is outrageous, it's people in their local county councils, local legislatures, saying through their representatives, this can't happen, and we demand our federal representatives to change it. So hopefully what's going to happen this year is we're going to see a lot bigger fight about this in Congress, because of all of what's been happening across the country. And I understand, and I'd love to hear folks' thoughts and involvement with, if any. I've heard that there's an anti-indefinite detention bill currently in the state legislature in Maine that's coming up. So I'd love to talk more about that. Yes.
Can you explain a little bit more how the NDAA came to be in terms of Congress and the President?
Sure.
Whose idea, how did it travel through and become law?
So it was a congressional proposal. I don't recall the specific person who decided to initially put it in the bill, but it became part of, so the NDAA is the National Defense Authorization Act. It's a bill that comes up every year that allocates all sorts of military spending, and in Congress they decided to insert these provisions ostensibly in response to terrorism that declared if you're part of or associated force of Al-Qaeda that you're essentially subject to this indefinite detention. And President Obama, when this was happening, was talking a good game about saying that he would veto the bill because of these provisions and that he was opposed to them. and that Congress needed to take them back out. But that didn't happen, as you can tell. What happened is that it was passed, and then I think on New Year's Eve or right after New Year's Day, I forget which, President Obama quietly signed the bill on kind of a dead news day, and then issued a signing statement saying that theoretically it was his administration's policy that he wasn't going to enforce these provisions. But folks should know that a signing statement doesn't mean anything really. It's simply a presidential expression of what they are or not going to do in relation to a piece of legislation. It has no binding authority. So one, President Obama, I mean, I think we all can cite, off the top of our head, any number of promises he's broken, particularly in relation to civil liberties issues, Guantanamo, things like that. So we should know that one, I personally, and I don't know about other folks, but wouldn't trust him to abide by that. But two, that it won't have any bearing on future presidents as well. So just because he signed something saying he theoretically will enforce it doesn't mean that, it's still law. So, yes?
There's a drone surveillance bill pending before the joint House and Senate Judiciary Committee in Maine right now. It would require the police to have a warrant before they could use drones to surveil us. The Maine Attorney General is opposed to that. She doesn't want the police to have warrants. She wants the police to make the rules to determine when and where they can surveil us. And it appears that the Democrats who control the legislature, because she's a Democrat herself, don't want to go up against a woman that used to be actually the former vice president of the Democratic Party in Maine. Would you comment on her opinion, though, that the police shouldn't have to have warrants before they surveil us with drones?
Sure, I'd love to, and thank you for bringing that up. I was going to get to that topic. It was perfect because you're knowledgeable about the bill, and I'd love to have a conversation about it. So we, the Bill of Rights Defense Committee, me personally, I suspect a lot of you in the audience probably disagree with that we think it's clear under the Constitution that at a bare minimum, that if you want to use a drone to spy on someone, law enforcement officers should at the very least go to a judge and say, here is my probable cause that I believe someone is committing a crime. Here is the evidence of that, which I'll explain to you under oath to you, the judge, and why we need to use this drone to, essentially stop and prosecute this crime. So I think that's like the absolute floor. I mean, obviously people are arguing that that's not the case, but I think certainly it should be, and I would argue that the Fourth Amendment, which protects against unreasonable searches and seizures, I think in any particularly reasonable or educated interpretation of that should require that. I don't want to, please.
No, go ahead. I didn't mean to interrupt you.
Oh, okay. So we have, and I can get into more, the Bill of Rights Defense Committee has released 2 sets of model legislation related to drones for exactly this type of purpose. One that bans the use of drones in a city, state, or locality and says that no one can use them for any number of reasons, because they're unsafe, because we worry that they'll be used to spy on us, because it's just an unproven technology. That's sort of one model bill that we have that folks could take a look at. And the other one is a bill that regulates the use of drones. And so what that requires is a warrant to use a drone, but it also puts a restriction on private actors from using drones. Corporations requires them to go out and get a license if they want to do it, puts limitations on the way in which they're using it to assure privacy, all of those things. So I think we could have a conversation about what that bill that's been proposed does or doesn't include, what could be added to it, what people think is important about including. So I'd like to talk about it.
I'm Little Freeport. I'm president of the ACLU of Maine. There are 3 important privacy bills that were introduced this session. This is a little bit off the subject of the NDAA, but one has to do with drones. That bill's been tabled by the committee. There's another bill which prohibits cell phone tracking or using the GPS device on your cell phone or any other GPS device to track your location. That bill got an ought not to pass recommendation from the committee. The Attorney General also opposed that bill. And there's a third bill which is yet to be heard, which would require a search warrant before the police could access your cell phone text messages or email. Currently, the police can go to Verizon or tell or whoever they want to, and they can simply on request of a letter from the local district attorney, get all your cell phone records, and we put in a bill which require a search warrant to access your those records also. The Attorney General is opposed to all three of those. So if you want to speak to your local legislator about that, I think, I'm sorry, I don't know which side Stan Brzezowski's on that.
Well, can I just say that
Yes.
Charlie Priest, who represents Brunswick, is co-chair of the Judiciary Committee.
I think
So-
he voted against the bills too. I think he's opposed to the bills.
Yeah, he is.
Yeah.
So he really needs to hear from
Yeah,
people
he
in
does.
Brunswick. Charlie Priest.
Okay, Regis, you had a question.
I had a follow-up question to Rosie's. I'd like to know if you know, or anybody knows, where the pressure came when Congress to pass both the Patriot Act and the NDAA provisions. I mean, Congress doesn't act unless there's pressure. I'm sure during the Bush administration, Cheney was the guy, beating up on people, but do you know where the pressure came from? Was it outside money groups? Was it within government? Was it the military? Where could it have possibly come from?
Well, the opposition the NDAA is a complicated bill. There are some conflicting provisions in it. There is the provision in it which provides for indefinite detention and without charges and without access to an attorney of anybody that's been associated with what's deemed to be a terrorist organization. Senator Dianne Feinstein had introduced an amendment which said that you can't use those provisions against a U.S. citizen or a person who's lawfully in the U.S. And that passed, but it was opposed by people like, pardon me, frog in my throat, John McCain and Lindsey Graham and Carl Levin, Democrat. So it had both Republican and Democratic opposition. My sense of it is, and I'm not an expert, I don't lobby in Washington, but that there is a bipartisan sense that this is a time of urgency which requires the booting out of essential provisions of the Constitution. What makes the NDAA complicated is, although Feinstein's amendment passed, and it says you can't use the indefinite detention provisions against a U.S. citizen, thank you very much, or a person here lawfully, there's another provision which says nothing in the NDAA shall be construed to affect existing law or authorities. What that refers to is the 2001 authorization for the use of military force, which was the post 9/11 resolution. And both President Bush and President Obama, in his positions, I think a little bit unclear, but I've taken the position that that provision authorizes them to use indefinite detention. So you have that specific, and there's nothing in Feinstein's amendment which spoke to people who were here lawfully but weren't permanent residents or citizens. And the Constitution, the Sixth Amendment protects all persons, regardless of whether they're citizens or lawful permanent residents. So Feinstein's amendment didn't go far enough, and then the subsequent provision which says that it doesn't overrule other law, which is the Authorization for the Use of Military Force Act, seems to contradict it. So the act is internally contradictory. It's been ruled that provision has been ruled unconstitutional by one U.S. district court, and it's now on appeal to a court of appeals. I think it's the Second Circuit. And it's conceivable they throw the entire case out and say nobody had the right to have standing to bring the lawsuit. So this controversy is going to rage for a long time. I didn't directly answer your question. I think it's just a bipartisan sense of, response to what's perceived to be a national crisis. I mean, you heard some of that being spoken by the man on the street in Boston post the bombing. I mean, there were a couple of people who interviewed who said we ought to have martial law, and I sort of made my hair stand on it. But there's kind of that national, and it seems to repeat itself throughout our history. Every time something like this happens, we react in a knee-jerk way to immediately start clamping down on rights that we've all thought were essential. And that happened in World War II, and it's, who knows what happens after Boston.
Two questions, if I can remember the second one. The first one is, do you think NDAA would have came about if not for the successful passing of the Patriots Act, which again is, NDAA is just an extension of it, it's just covered all the bases. And two, I believe there were only, and you can correct me if I'm wrong, 2 representatives of the federal government who voted against the Patriots Act?
I don't remember the exact vote, I don't have it in front of me. But I know that opposition was not widespread, certainly, that, most people supported it without, in fact, I think, reading the whole thing, because it really happened in the dead of night, essentially, and was pushed through Congress without sort of a full vetting, which I think happens with a lot of legislation. It's like a total failure of the democratic process for a lot of things, but this is a particularly awful. But I think to your future question, I think the Patriot Act in a lot of ways really did lay the groundwork for these type of laws that run roughshod over constitutional rights and civil liberties, and really show the success of using the sort of fear of so-called national security threats to strip away a lot of these rights and liberties and push them through without, a terrible amount of pushback. It wasn't, as big of a fight as one would have hoped over this. So, yeah, I would definitely agree with that.
How do we get it back? How do we get our Constitution restored?
So I think that's one of the things I'd love to talk more about. And our theory about this is that one of the most effective ways to do that is, as I was talking about before, to really push for your local and state representatives to pass bills or resolutions that either simply declare your opposition to these things and your demand that Congress change them, or to pass things that effectively change the law where you live. So there's a lot of things you can do that sort of restore constitutional rights and liberties and place limits on effectively these type of heavy-handed tactics that have a real effect on where you live. So for example, if you're someone who believes that, federal or local law enforcement shouldn't be enforcing local immigration law, you can pass, in a lot of states and city councils, you can pass measures that say that our local law enforcement isn't going to hold people for ICE, for immigration and customs enforcement, that we're not going to detain someone simply because ICE has asked us to pass when we're holding them on a crime, that we'll hold them if they've committed a crime and put them through the system, but we're not going to keep them after that simply so they can be deported. We don't believe that's our role as local law enforcement. That's not something we should be doing. You can do things where if your local law enforcement is acquiring drones, tanks, military technology, which is going on a really shocking amount of jurisdictions across the country, you can work with your city council, your state legislature to put restrictions on that, to say if our police force wants to acquire military technology, that is going to be reviewed by the city council or the state legislature or whoever has authority over that law enforcement agency, and it's going to come to a vote, and we're going to have public comment on it, and we're going to have a debate and talk about whether that's something we want or not. We're going to have a debate about whether we want our law enforcement to be acquiring drones. It's not simply going to happen because the police commissioner or the police force wants it to happen. We're going to have a voice in that process, and if we don't want that to happen, it's not going to happen. So I think in a lot of ways, you can stand up by really saying we, the people, have control over our government, and this simply won't happen without us, having an input. John?
Remember, after the Patriot Act, there were, I think, 400 or so municipalities throughout the country who expressed opposition, formal city council, mayoral opposition to the Patriot Act, and said, we are not going to implement that here. Well, these are potential allies, and something that we could think about organizing in that direction.
I just wanted to agree with Michael. I think the most important thing we can do is to effect change by getting the Maine legislature to act on certain bills that protect our civil liberties and privacy. We obviously can't affect John McCain or Lindsey Graham. They're not going to listen to people from Maine. They don't care about it. We don't vote. We're not their constituents. I think the Maine legislature enacting to, for example, prohibit the use of drones without a search warrant would send the message to Susan Collins: when you vote on national issues, the people of Maine don't want the federal government using drones. They're surveilling without a search warrant. I think that's the best way for us to really be effective.
Yes.
I have a question for any of you up there, really. We're becoming aware of drones being used for surveillance. And I'm sure everybody in this room was as troubled as I was to see UC Davis campus police in full riot gear with semi-automatic weapons. Anybody that watched for a couple of minutes the event in Boston saw the Boston police in full riot gear with semi-automatic weapons. Our game wardens here arrested a few people at the Blaine House, and they showed up in riot gear, not with the semi-automatics, assault rifles, but is there anything happening in the country to roll back that kind of foolishness? I mean, we've militarized our local campus police and local police, and we didn't even know about
It's
it.
a little easier in smaller places where you know more folks, but it really takes building a coalition of people across, I would say, political lines, across ethnic lines, across economic lines to really gather a critical mass. But what folks in Berkeley were able to do is they saw that going on. They saw that their local police force was acquiring military-type technology. There's this thing called urban area security grants, essentially, where folks can apply federally to get all of this money to fund exactly that. And people didn't want that to happen. They were like you. They said, we don't want our local police to become this paramilitary force. That's not how we want to live our lives. That's not how we want to go about doing local law enforcement. And so what they did is they passed a city council bill that said if our police force wants to go out and get any of those things, they have to come to the city council. They have to say, we are applying for this. The city council has to have a hearing on it. They have to have public comment, and they have to vote on it. So every time they want to go out and try and do that, there's going to be a vote. We're going to show up right back here, and we're going to tell you no, unless there's some great reason that we haven't heard of yet, but we're going to be a voice to prevent that from happening. So not only is it a tool to stop that, it's a community building tool, and it's an organizing building tool that allows people to come back and have a flashpoint to get involved and be active there. So that could really be applied more broadly, and I think it looks different in different places depending on exactly what authority your city council might have over the particular law enforcement agency, but it's possible, and I'd say that that's a great solution to that type of thing. So, yeah.
Another question.
Well, suggestion actually, it seems to me to keep federal from when they both break and go against the Constitution, which is kind of ironic. Because
Can you speak a little louder, please?
Sure.
Maybe if you stood up, we could hear you.
Sure. It's quite clear in the Constitution that the states, which you pointed out in Amendment 10, the states' rights supersede, unless specifically detailed in the Constitution, federal, or it limits federal government. So the suggestion is, in conjunction with what you've been saying as well, we need to restore the rights of the state to keep the federal government from enacting these tyrannical laws, which are unconstitutional and therefore illegal and against the spirit of how this country was formed. Two, both major parties are directly responsible for these laws. Perhaps at a grassroots level, we can suggest when they've gone against the principles of the party they represent, they be stripped of their party affiliation even while they hold office. Seems to me that might be a deterrent.
If there was people in that party that had the guts to do it, it might work, but apparently there aren't people in those two parties with the guts to hold their own representatives, hold them to the Constitution.
That's where we bang pots and rattle cans. And
We
got to try because it is disastrous where
We have
we're
to
at.
rattle our chains. Rattle our chains.
There's some issues there in terms of nullification and when it's appropriate for a state legislature to say we're not going to abide by federal law. And I'm wondering what the strategy has been at the federal government, because the system is designed so that the courts would decide the constitutionality of federal law, not necessarily state legislators. And I'm wondering why that is failing us in this situation. Why are we not able to get federal courts to perform their role? We assume that the Congress occasionally is going to overstep itself, and we assume that the executive is always going to assert more authority than it should get. And the checks and balances in our system are that the court, the judicial system, is supposed to provide a check. And why is that not working in this case?
Well, I think that's a complicated political question as to how judges are appointed and the political forces that work on that. But there are currently a huge number of vacancies in the federal court to begin with, because those who are on the opposite side of us on a number of these issues and social issues have been much more active in opposing the appointment of judges by Clinton and by Carter and by and now Obama. So they're simply not able to get appointments through. As you recall, during the last session, I think there was a federal judge from Maine who was certainly not a political character. I know him, Bill Kayada. He was finally confirmed, but his appointment languished in the Senate Judiciary Committee for months. They simply weren't going to, they were not going to act on it because he was an Obama appointee. And the way the Senate works is any one senator can put a hole in any nomination forever. And that senator doesn't have to be identified. There are a number of arcane Senate rules which opponents of presidents who would appoint judges whose views they don't like, they now use those parliamentary tactics to block nominees. I think a huge percentage of judges that are serving now in the federal system were appointees of the Reagan years, when Democrats, rightly or wrongly, didn't use those same kind of tactics. So the whole process of appointing judges has become much more politicized, and they tend to have they tend to go in with a clearer political agenda, all of which results in them ruling the way they do. Judges are not blank slates. They bring to it their lifetime experience and all their views on things. That's why you end up getting the rulings that you do. I mean, you just have to look at the Supreme Court, where look at who votes which way and ask who appointed them, and it's pretty clear that they were appointed to because they espoused a political interpretive philosophy of the Constitution.
So,
and I don't see that battle changing for a long, long
so
time.
do you think that that basic premise then, that we can count on the judiciary is flawed now, and that the process, because we're not appointing judges and because it's become too politicized, the basic structure and framework of our government's broken?
Well, that's a really big question.
It's really scary that the federal courts in a lot of these jurisdictions have really taken their hands off. You look at the Supreme Court with Guantanamo. I had a client there. We appealed to the Supreme Court recently with a number of other prisoners there, and the court threw up its hands and essentially has washed its hands of the issue. It doesn't want to hear Guantanamo cases anymore. It had a couple of decisions that really stepped in, and now it's backed off and let the federal courts in DC deal with it. So I think it's a huge problem. But yeah, I agree with your assessment that there's a whole host of factors, a lot of them political, that go into it. But I mean, that points to another potential area for political change, where if we really support state, local, and federal candidates that reflect our beliefs, maybe we'll have the power to push for judges who really do respect the Constitution. So, yes?
If I could ask a question. I wonder if we are confusing some terms and making some assumptions that may not be correct. We talk about state law as constitutional law. We're talking about federal law as though that's constitutional law, and yet a lot of what is happening is military law. Are we confusing federal law and that floor of federal civilian law with military law?
But I think you raised an interesting question about the conflation of military law, the laws of war, normal constitutional law.
I think we're confusing the basis of some of this.
Well, I think you see a lot of people really, I think this morning McCain and Graham, I think, said that the guy from Boston should be tried as an enemy combatant and things like that. I think you see really and this is what we were talking about before with the AUMF and the authorization for the use of military force, that we've created essentially this wartime framework that a lot of people in Congress, and I think maybe the president, want to really extend indefinitely into the future in the guise of a war on terror that's kind of never ending, and to really supplant what should really be the baseline and should really exist, except in great, great exceptional circumstances, just regularized constitutional law. We're not in a conflict as was understood when sort of the laws of conflict were developed right now in most places, but yet congressional representatives and President Obama seem to want to use that framework because it's more convenient for them, that it really allows them to strip away rights. And I think what we've seen is that in a lot of ways, there's no need for that. Our civilian courts, our federal courts are really effective in ways that I think I'm actually uncomfortable with, and a lot of other people are as well, that the decks are stacked there too. But at the very least, I think it's absurd to assert that we need, a military court to try a terrorist suspect, because, the conviction rate in terrorism cases is like 99%. It's not as if the federal courts have a problem with prosecuting people with constitutional rights and convicting them and putting them in jail and keeping them safe. That's been extremely effective. So,
I think one of the issues that are to be raised is in the original founding, there was the balance of power. Each had checks over the other. There was the executive, the legislative, and the judicial. And that's a very good triangulation, to use a more contemporary word that makes a lot of sense. However, each of these has now been taken over by corporate interests. So we have a corporate government, which is another way of saying fascism. And I think we need to address that front and center, because every one of these, they're interchangeable. They go from corporations to government and back again, willy-nilly.
People are afraid. People are afraid. This is basically what the Nazis said. It works the same in every country. You get people all worked up, they're afraid, they're willing to give up their civil rights. Our system has been premised on the idea that the judiciary will put a limit and will declare certain laws unconstitutional. And I heard from the ACLU person, but I'm not sure I heard from you. Why isn't that the focus of your organization? Why aren't you trying to fix structural problems with the judiciary, try to make sure that the judiciary can perform its critical role in our democracy?
I'd like to make a brief comment and then I'll pass it over to Michael. In order to be appointed a judge at a high level, certainly they have to have an ideology and methodology rather consistent with the corporate dominant rule. They're not going to usually get into positions of high power, I think, without a certain acquiescence to that
Just
level.
to push back on that point, I think your point is really applicable to people in the executive and the legislative, but it's really, honestly, not as applicable to the judiciary. There are other problems going on, and I'm really curious to know what organizations are working on the problems we're seeing with our judiciary. That it's not, it seems to me, it is failing in its critical role, and why is that happening? What could we do to fix the judiciary? Or maybe you've already thought about it and you're saying you don't think that's the problem.
So I guess I'll explain a little bit maybe of how our organization thinks about it and then turn it over to you. So I would say, I guess while we're talking about state and local legislatures and the role that they can have, I think our organization's view, and I would take this personally too, is that the real purpose of that and the power there is not so much in the state legislature themselves, but it's in the people. And you're not going to really change anything in this country without an extremely strong social movement that builds across boundaries, that really encompasses anyone who agrees on that condition, that it can educate other people who might not initially agree and bring them across. And I would say that's really what commands the power. And working on legislation has some sort of things that it can do in and of itself, but in some ways it's a means to really build power and to build a movement that stands up for these type of things that we care about. And so I would say that that's what we're really after. Our organization is about coalition building, is about movement building, and the state and local legislatures are sort of flashpoints to focus on to exercise and build that power. As to judges, it's not something we as an organization so much focus on particularly changing that. We do, like I said, work with people to do amicus briefs to really educate the judiciary in hopes that that might sort of push the needle or inform the judiciary about some particular type of things. But I would suggest that they're extremely important, but sometimes they really don't have the power to change things. So I don't know if you look at like Brown versus Board of Ed or something like that, that declared segregation illegal a long time ago, but if you look at the state of schools in this country and patterns of segregation, they're not all that different than they were. Just because the judiciary declared segregation unconstitutional didn't mean the country changed. It really would require a far broader changing of social and economic patterns and racial understanding and progressive thought and education to really shape that weighty issue. So I think what we're after is something more fundamental and broad-based, and we see judges as one important flashpoint and tool there, but not sort of the be-all and end-all of fixing a lot of these problems. So I guess
I agree with Michael that I think major changes that have occurred in the country have partly occurred in the courts, but in most instances have occurred because of a groundswell of change in national attitude about a particular issue. I think that we forget, when we say, why aren't the courts doing their job, we forget that the courts didn't always have waxed and waned on that. When you look back at Plessy versus Ferguson, which for 150 years was the law, came from the Supreme Court, was said separate but equal is constitutional. The Dred Scott decision, all the decisions of the New Deal that outlawed a whole host of the New Deal legislation. It's not as if our concern about the courts now is the court's failure to address certain problems is a new problem. It's existed from time to time throughout our history. And sometimes the courts are ahead of society, as it was in Brown versus Board of Education, and sometimes they're behind. And I think that's, all sorts of complicated reasons for that. Just human nature. And one Supreme Court judge, that name I now forgot though, once said that although people think that the Supreme Court justices live in these ivory towers, he said, in fact, we read the papers. Which means that what he meant to say was, we're not isolated from what we see as being groundswells of public attitudes. And I think that perhaps one of the best ways to change the courts, and I mean all the courts' attitude about civil liberties, is to have a groundswell of public feeling that was just articulated about it. I mean, now there's a lot of people out there who believe that the Lindsey Graham's and the John McCain's view of civil liberties is the correct one. And until there is I think an upswelling of public attitude which says, no, that's not right. We think that goes too far. He's taking our civil liberties. You see a broad attitudinal change in the courts. For now, they mostly tend to try and duck it. And there are a lot of civil liberties cases that have come up to the Supreme Court and they refuse to take them. There's a whole host of cases out there which simply aren't making it the way to the Supreme Court. These issues aren't being decided because the court doesn't want to get involved, frankly.
Well, whenever we talk about the need for public outcry and a public supported movement, then we have to think about the corporate-owned media, which prevents the news from getting where we'd like it to get. So it's quite a circle that we're struggling in. A little, maybe a whirlpool is a good image. Very hard to
Not get sucked in.
well.
I'd like to thank everybody for coming and thank Michael and John Olson, and thank you so much for bringing us together. Trying to find some way to keep in communication, and we can put chairs